All right, Marshall.
Hi, Greg.
Hey, all right, people will be entering in a minute. Sorry for those watching the recording. Well, actually, for those watching the recording, they will not know that we were late getting this started because I'm incompetent when it comes to configuring StreamYard to work the way it's supposed to. So we are here. I think we've been gone for a couple weeks. I don't think I've been back since my mountain biking trip in England, and saw some plays and some other things in London. Anyway, it was a wonderful time, and I got to forget about U.S. immigration for enough time that you can never get it totally away from this because obviously you have clients and emails and all kinds of things like that. But it was a good break, and I do this bike trip every summer, so it's always something that keeps me going for months, waiting for this trip. Anyway, how's it going, Marshall?
Pretty good. You didn't miss anything in the immigration world where you were gone.
I figured. However, yeah, we really struggled to come up with like developments for this week. So we do have actually 9 things, I think, for tonight. And I actually, just as we were prepping for this, let's see if they're here. So we'll go ahead and get started. I don't know if we'll have how much energy we'll have for questions for tonight, but we'll at least give you a quick overview of these 9 big things that happened in immigration law basically over the last week and a half. So thing number 1, and this is not necessarily in order of importance. We threw a couple of things in that are kind of lighter, but they all 9 things in the aggregate are important. So, Marshall, this is bad news. Matter of Eric Belly and Yarrabelli. This is a BIA case that why do we care about this thing, and what does it mean for DACA and others as far as the ability to give us the big overview?
Sure. So it's this new decision called Matter of Del Carmen and Lara is changing roughly 14 years of precedent of what it meant to be able to travel outside on advanced parole, depart the U.S. without triggering an unlawful presence bar.
Right.
So under the new rule, if you have advanced parole, like many individuals on DACA or TPS or other humanitarian means, you no longer have this safe harbor to potentially correct an entry without admission, or to return to the U.S. to cure that for an adjustment of status. So it's fundamentally changing.
So this is like, what about people who already traveled and came back in under advanced parole? What does this mean?
Good question. So it's the new decision was made on August 13th, and it should be applied prospectively, is what the decision says. I think there's some ambiguity or gray area of how it's going to be applied prospectively, maybe for individuals already abroad on advanced parole and coming back. It seems like they should have a good case to not be harmed by this decision if they relied on it, but we'll see.
Anyway, it's bad. It's very bad news for people that have not taken advantage of advanced parole, and it's kind of important because when you are able to re-enter the United States as a parolee, if you look at the for purposes of adjustment of status to permanent residency or some other statuses, entering in parole allows you to pursue them. So for adjustment of status, 245A, I believe, says that it applies to people who are admitted into the U.S. or paroled into the U.S. I believe the language of 245A says that. So if you've actually been paroled in, then you can potentially pursue adjustment of status. Not everybody, but a fairly large group of people have been able to pursue green cards that were on DACA that were otherwise ineligible to apply for adjustment of status because they didn't have a legal entry when they when they came as children. So this was a way to basically regularize or change enough about their immigration situation to be able to then have a pathway toward permanent residency. Um, that's a so obviously that's not great news, and that's going to impact a lot of DACA recipients. It's going to impact people on TPS and others. So not good. I haven't heard about litigation yet on this particular one, and whether people think that there is, just because it's a mean and horrible policy doesn't always mean that it's going to be okay. I mean, that we'll be able to be successful from a litigation standpoint. Um, I'm sure there are discussions going right now about how this is about this, but at this point, this is the policy. So we'll keep people updated as time goes on. Anything else on that one, or do you want to move on to number 2?
Let's keep going. We got a lot on our plate
All right.
tonight.
Public charge and admissibility. So we got this mean public charge rule several weeks ago, and now we have the some guidance from USCIS on how this thing is going to actually be implemented beginning September 18th, 2026, when this rule goes into effect. So, Marshall, you were probably not. Were you? I don't know if you were practicing when the last attempt by the first Trump administration happened, where they issued a 300-page public charge rule that never actually went into effect because there was litigation before that. This was back in the ancient history of the I think 2018 or so when it came back. Yeah, I remember I took almost a week off of work to absorb that rule and then write a web application. It was my early AI days when I was creating these expert system apps that would basically walk through lawyers and non-lawyers through questions to figure out whether they were slammed or not slammed by the public charge rule then. But that's not going to be quite the same this time, because this one is a lot more loosey-goosey, I guess you could say. Last time it was very black and white. If you these were the rules. If you were inside the rules, then you were a public charge, and if you were outside them, you were fine. But they're taking a different approach this time. Am I right?
Yes, there's a lot of discretion in how the USCIS is going to be reviewing public charge.
So basically, it's whatever the examiner feels like. It seems like it's not quite that broad, but it is broad enough that they are looking at basically the totality of the circumstances, which is basically code for the examiner can just make their own call on whether a person's a public charge or not. So they're supposed to basically look at a number of factors and then make a decision for themselves, but the factors themselves don't have tight rules. So they're looking at things like age, financial status, family status, skill levels, health, affidavits of support that are provided. They're looking at all these things, and then at the end of the day, the examiner is basically makes the call on which that's if you think that that it was, I mean, it didn't last. It never saw the light of day in the last administration, and that was one where it was like really clear how to follow whether you were covered by it or not. I'd be really curious about how this one fares in a way where examiners basically have almost total discretion to say, no matter what your situation is, that they think you're a future public charge. I mean, it's not quite that broad, but it's not that much less than that either. So I guess that we were talking about this at our attorney lunch today, about how how to advise clients when, about how to comply with this thing. And I think mostly what we're going to have to be telling clients is this thing exists, and we can't tell you for sure whether we can give you some of we can keep you up to date about what the government's saying about it, but we can look at all the documentation you have right now and still not be able to tell you definitively whether you're going to uh, be impacted by this or not. So, really what we're just going to have to do with clients is like, these are things we're hearing about that are causing problems, like need-based financial aid, which is mentioned in, I think today in the guidance that came out, or like all kinds of things where they would not be considered normally in the past such a big deal. Um, but I think the bottom line is that you are going to have to show that you have that you have an income stream that's predictable, that you have not applied for anything in the past, that that was available based on your particular needs, um, and and then just kind of watch decisions as they're coming in and what we're hearing about in order to advise clients. So um, I can't believe this thing is not going to get litigated, but we will see. On I guess September 18th is when the rule takes effect. So uh, whether you're employment based, family based, or whatever your situation is, all this stuff is there. And then also, this is just this is just USCIS. So I presume we're going to start seeing this kind of stuff at the State Department level too now. No, don't be frozen, Marshall. Hopefully, you'll be back in a second. Marshall, tell me when you're back. Okay. I will keep going. Um, State Department expedites B1, B2. Oh, you're back. All right. You froze up for a little bit.
Okay.
Well, we can go back to the public charge. I don't know if there's anything that in addition that you wanted to add, but I think the takeaway was just that you need to probably have early communications with your lawyer about things that might be, if you're aware of things in your background that, especially if you've ever taken any kind of benefit that was based on your annual income, and be aware of that. And also, if you've ever taken any things like health benefits, and also if you have any chronic health issues or serious health issues, talk to your lawyer about that early on as well. Because if in theory, if you have some kind of condition that's going to be expensive over a long period of time, there's enough leeway that an examiner could potentially use this against you, if you can't prove that you have the income or the assets to cover all those expenses without government insurance. So I wonder about, I don't know about eligibility for like the Obamacare and the exchange, but I imagine that those are also going to potentially be factors if you qualify for like a Obamacare policy based on income, because they're subsidized, and if you're under certain incomes, you qualify. Not an expert on the Affordable Care Act, but talk to your lawyer. Okay, let's keep it moving.
Mhm.
So this is your territory. I about this new B1, B2 appointments. We've got so explain. This is good news, actually. So we have a couple of items of good news sprinkled in, and I would put this in the good news.
Mhm.
Maybe, I mean, I don't know. It depends on how you look at it, but I think anything that like locks the government down to performance standards is good, and this is not as expensive as I would have thought. So tell us what this is.
Yeah, so this is the State Department's attempt to address some of the issues with the really long backlogs for B visa appointment interviews across the world. There's some consular posts that are taking 6 months to a year plus to get an interview appointment for a B tourist visa. So State Department implemented a pilot program to allow for expedited processing, visa appointment processing for B visas. It started in Mexico in July. It was launched, and you pay $750 to go in a fast track for a visa interview appointment. And it was just this week they announced that they're going to expand the pilot program to another handful of posts throughout
Central
Central
America.
America. Yeah, Central
And
America.
Bogota also.
Mhm. Right.
So we got Bogota, Guatemala City, San Jose, Costa Rica, and Tegucigalpa, as well,
Honduras.
Honduras.
Yeah.
Okay, so hopefully this will become more widely available. And obviously you don't need it if you're, well, you usually won't need it if you're from an ESTA country, a visa waiver country. But for a lot of countries around the world, this is going to be pretty welcome especially for business visitors that have to get to the U.S. fairly quickly. Okay, so that was thing number 3.
Yeah, it's not going to guarantee an approval by any means, but it'll get you a faster appointment.
No, I mean, right, exactly. Don't expect this to lower. Well, I mean, I guess if you can pay the $750, that might help show a little bit about like your income capacity that you might not have to. Honestly, I mean, it's like, I don't know, like, in terms of what you have to do obviously you want financial ties to the home country, but for this, administration, you might maybe like, I bought first class tickets. I'm staying at a 5-star hotel. I mean, those are the things that I think that at least in this administration they want to see. All right, we'll move on. So more good news. So we're going to talk more about when Adam Cohen was here, we talked about the duration of status rule and what that's about, and that's that rule I think is effective September 15th, I think.
Yeah.
But there's been a major lawsuit that was filed this week by a bunch of universities and civil rights groups seeking an injunction, warning of severe backlogs and academic disruption from the rule. So this is the rule that basically FJs and I visa holders for the entirety of my legal practice. I don't know when this started, but let's just say it's we're talking 1980s or earlier. That basically instead of getting an I-94 with the definitive end date, they get an I-94 that says duration of status, and it's tied to the dates on the I-20 for students, F1 students of the DS 2019. For J1s, I'm not sure how they kept the dates for the I visa holders. Don't do a lot of I visa work. You probably do more of that than I do. But in any case, it was really good for the universities and for the exchange programs and for because they had a lot more flexibility basically to you didn't have to wait on the government to keep somebody in valid status in your student program or in your J1 program. And we did talk at our lunch today. I asked the specific question for our J1 doctors, and we do a lot of work for doctors. Like, how does this like impact our clients? In September when we start to see this. And the one thing Elisa Taub, who heads our healthcare group, was talking about were doctors who, after their training programs are over, extend their J1s in order to be able to take their board exams and get certifications as specialist doctors. A pretty important thing for credentialing, but also a really important thing for Americans that know that their doctors are qualified for the specialties that they are marketing their services. So they want to take these board certification exams, and then they can hold themselves out as specialists in certain fields. That's going to be a lot harder now under this rule. And there's this theme for my entire practice of the government pushing out statutes or rules, whether it's Congress or the agencies, that inadvertently screw over doctors. Sorry for the for being blunt there, and cause problems for the healthcare system that nobody thought about because they don't think about those things when they're thinking about cracking down on immigration in one way or the other. And this is one that I there are some workarounds that potentially we can do, but it is going to be disruptive for that specific community. And there's plenty of others that are, but that's just one example of a problem that's going to come up when you can't easily extend a person's J status by just issuing a DS 2019 to take them out long enough to be able to take board certification exams. And there are others. So we've got this lawsuit pending. I'd like to have Adam Cohen probably on down the road to be able to get into the sort of the weeds about the suit itself. Adam is our university maven, immigration maven, and he is. I'm looking at his book right now. He writes the Academic Immigration Handbook. Very, very in the weeds on all things F1 and J1. So that's thing number 4. Thing number 5. New forms. Why do we care about new forms?
If form mess up can be the end of your application. You'll have to do it over. But yes, we got new forms coming in September. There's a new forms for the I-539, change of status, I-765, and the I-45. There's not going to be any grace period.
These are changed to new policy. I mean, because of new policies that are coming. So I mean, they're not innocuous where they're just changing something minor on the forms. They're basically designed to implement a lot of the policies we've been talking about, including the duration of status change rules and some of the other ones that we've been talking about. So that is those are coming. Particularly important to note September 15th. If you're filing anything in mid-September, be very, very cognizant of the form and the date that you're sending it, when it's going to get there, what the version of the form is that you're using. This is something that happens regularly in immigration, where people get applications rejected because they used an out-of-date form. And it used to be that forms didn't change all that often, so it wasn't that big of an issue. They change a lot more now than they used to. But just note that if you're filing any of these 3 application forms sometime over the next several weeks, make sure you're using the right version. Okay. Thing number 6, mandatory e-filing. So this could be good news, could be bad news, depending on how much you trust the government. But basically, in this case, so the Department of Homeland Security, they issued an interim rule, and this is basically that saying that if a form has been available for online filing for at least 180 days, USCIS will have the authority, and I don't know when this starts, they will have the authority to basically, well, they have to give a 60-day notice period, but they can kill the paper form in those circumstances. So it has to be available for e-filing, has to be available for at least 6 months before they can do this. They have to give 60 days notice that they're doing this. And then after that, that can be the end of you could be required to file it online. This, I think, is more painful probably for immigration lawyers than for the clients, probably, because immigration lawyers right now, they rely heavily on very sophisticated case management systems where they manage all their data and they can push out forms. But USCIS has not made their API available for anything but, I think, FOIAs, and there may not be any others. I can't remember if there was any other forms yet, but we are not going to be able to push information from our case management system into USCIS.gov's form filler So it means that it's all that everything's going to have to be entered in manually by your law firms. That pushes prices up. That also makes cases take longer to file. That's not good for our clients. It's not good. It's probably not good for the agency because it also increases the likelihood that you're going to have mistakes that are made because every time you have to transcribe things from one place to another, you have problems there. So that part of it is not good unless USCIS, which has had years to deal with this, actually starts pushing out APIs. If they push an API out for each one of the, so that these forms will work with case management systems, that'll be great. Visa AI, where I'm co-founder, we have an API. USCIS requires you to get approved. We have approvals for that, but basically the only thing we can use it for is collecting information from the from USCIS's status checking system, but we can't use it for anything yet from the point of view of actually filing anything electronically, other than FOIA, which is nice that FOIA is available. It's an important one, but that's the main bad thing. Good thing is for e-filing though is that in theory they'll be able to work cases more quickly if they don't have the humans that actually are pushing the information. They get these paper forms, they scan them in, and they push them into their own internal electronic system. I mean, they really do need this system. Um, they just need to take the next step of making it possible for these case management systems to work with it. But in theory, it should be faster adjudications, probably fewer human errors when there's no human that's actually moving information from paper into their electronic systems. There's like a bunch of good things that will happen once we get to the point where e-filing is true e-filing for us. Okay, moving on. Thing number 7. This is one actually that a lot of people probably haven't heard about, but I don't think that we got. I don't know if we actually got notified about this from any of the news services that we typically see. But the League of Women Voters, which is about as all American apple pie as you get, had to sue USCIS. Why did they sue USCIS? Because they have had a long tradition at the League of Women Voters, and they run the presidential debates. And well, they used to. I think they don't do it anymore. But among other things that they've done, which are apple pie, all American, is they were at a naturalization ceremony. They would set up a booth, and they would register people to vote as soon as they were sworn in by the judge. That's one of the greatest things that you can do as a newly naturalized citizen. That's like the one thing that like people are most excited about is that they get to be a full participant in the American democracy. And then the Trump administration decided we don't want that anymore. We don't want them there. And they didn't replace it with like their own voter registration. They just basically didn't want new citizens they don't want to make it too easy for anybody that they're not sure who they're voting for to be able to register to vote. So League of Women Voters sued and they won, and a judge ordered USCIS to cut it out. And they announced this week, it was in the USCIS policy manual, that they are now allowing NGOs NGOs or non-government organizations, that they're allowing them back at voter registration and naturalization ceremonies, and they can have their voter registration booths. So I'm looking for good news when we can find them and we can report to you. So that is maybe 4th good news, if you count the mandatory filing, which I'm not sure. That's sort of on the fence on there. At least 3 good news things that I've had. And there's a 4th one coming. But before that, we have a bad one. And this is actually kind of the one that immigration lawyers are probably talking about the most this week, even though there's plenty of competition for the worst thing of the week. And this is Marshall. This is basically USCIS during the first Trump administration. They issued a policy memo. I think it was they did by policy memo, giving them discretion to deny cases without a request for evidence or annoyed if they made a determination that there was that an application didn't have the minimum the minimum documentation to demonstrate eligibility for the category. I think you have to have enough to show you're eligible at filing. If you are going to be, although it's kind of stupid in my opinion, because a lot of the times the RFPs that come in, there's a question about a piece of evidence that determines whether you're eligible at filing or not. So they will ask for an additional piece of evidence to be able to clarify that. So I can see this basically in, maybe not every case, but a sizable number of cases that somebody in an RFE could satisfy them that they were eligible, that they demonstrated eligibility at the time of filing, by giving clarification on something that wasn't super clear, or providing an additional piece of evidence that supported the first one, or whatever it is. But this is basically like the whole thing about an RFE or annoyed is they have to actually explain themselves, like what the problem is. And it seems like, now you're just going to get a denial outright. I guess they have to explain themselves in the denial, but when it becomes apparent in the denial that they just didn't understand and they just denied, instead of asking you a question about your evidence and giving you a chance to explain further, they just go ahead and deny, that they're going to make a lot of mistakes, I think. And there will be a lot of situations where somebody filed in a timely manner and are now getting a denial that is undeserved, and then being in a situation where they're no longer eligible for whatever they were applying for because they're not in status anymore because they got a denial of what they were requesting, and even if they had filed it in a timely manner. So this is like bad. I'm wondering if if you had thoughts about it, but this is already in effect. Like this is not this is not one that has like a month-long or 60-day implementation date. People probably are already seeing this happening. We haven't had any, I think, in our firm yet, but it is something that I'm guessing that we'll start hearing in the next couple of days from people that are already experiencing this.
Right. And what it also does, Greg, is it gives USCIS discretion to shorten the RFE response windows that are typically given. Right now, in practice, we're seeing most responses given the maximum amount of time to provide responses, whatever the government needs more information. And we're seeing it, what something could take, 100 days to provide a response is now being brought down to 33 days. So it's going to have a huge impact on a lot of different case types.
Yeah. I mean, I can also see instances where, look, sometimes you're trying to file something to keep somebody in status and you're waiting on one thing. And sometimes you would be, you're going to get a request for evidence and it's going to fix it. I'll give you an example. Doctors again. So one of the issues that happens is that with J1 waivers and doctors having to file, they have to file within 90 days, attempt to file within 90 days of getting the waiver, the H-1B application. When you are seeking that H-1B application, you have to demonstrate that you already have a license. There are times when the license is pending, but it hasn't been approved yet. And you are basically, the doctor is risking going out of status because they're waiting on the state to finish up their licensing, and everything is ready to go. And this town, the small town in the middle of nowhere is counting on their doctor to get there at a certain point and not have to leave the country and potentially trigger all kinds of other problems as far as trying to get a visa to get back in. And USCIS's policy for a long time has been we'll just, we'll kind of be relaxed about it because there's policy issues why we want to, as long as they can, and basically what they do is they issue an RFP saying you're not eligible for this until you show us this. They have the now, they do have I suppose they have the authority to just outright deny. Um, and it seems like, there will be lots of instances like that where, common sense will prevail. And even if somebody is not eligible, they'll issue an RFE, give them some time to get what is needed because everything else is substantially there. And there's big public policy reasons why you want to be relaxed about it. I'm wondering if we're going to start seeing problems with respect to flexibility like that because of this new policy. Hopefully not. But that's it remains to be seen about how aggressive the agency is going to be. Um, they have the discretion. That doesn't mean that they have to. It's not mandatory that they, if they make a determination that somebody hasn't proven eligibility, that they have to issue it. So hopefully we get. This is the time when you kind of hope that career people actually assert a little bit of independence in the way they do their job and don't just fall in line as far as trying to, in the spirit of the administration, trying to deny as much as possible. They said they have discretion, and hopefully they mean it, and they're not putting quotas on examiners or doing other things that pressure them to do something that they don't want to do. Thoughts or move on?
I've got some. I mean, not the best thoughts that they're using this, as they typically do, trying to tighten or focus on fraud and the integrity of these applications. You see in the announcement that they're just, criticizing the Biden administration's prior policy, and it seems very kind of partisan, and they're just trying to make it as difficult as possible for everyone.
Yeah.
Yeah.
Just make it so that the situation is so the U.S. immigration system is so unpleasant that you'll find some other place to go. That seems like part of the theme. It's not originally they were talking about keeping criminals out, but it's really making it the U.S. immigration. I mean, for people that are perfectly legal and have a claims and that are desperately needed, it's just about less immigration and not less criminal immigration. I think that's been pretty apparent. It was apparent in the first administration. It's very apparent in this administration. Okay. Thing number 9. This is happy news as well. So Dorcas, what is this case? Dorcas is a is a case filed in Rhode Island by nonprofits that were challenging the legality of USCIS's nationality discrimination policy against people from 39 different countries, where they refused to adjudicate cases for people that were from those countries, even if they were dual citizens in other countries. They were not working on those cases, and we have a couple lawsuits that impact that we're working on that are in this area. But Dorcas got the rare national order on the policy. So the judge in Rhode Island issues this policy telling USCIS you can't have this policy anywhere in the country, and then the government sought a stay. A stay basically means we're asking you to put this to not issue this order until there's an adjudication actually in the case itself, beyond just a preliminary injunction. Case goes to the First Circuit. I mean, they lose outright, and then and then the case goes to the First Circuit. The First Circuit had a decision to make whether they were going to allow the policy to continue until they actually made a decision on the case overall, which would be many, many months. And that was one that we were kind of watching really closely, because a lot of times that does happen. Even if it doesn't necessarily mean that the circuit court is going to is going to rule in the government's favor. But sometimes they'll give the government the benefit of a doubt until they've actually had a full trial and made a determination on the issue. And in this case, the First Circuit said no. We're going to allow the Rhode Island judge's order to stay in place. So USCIS is at least for a while, has to comply with the judge's order. So now that's not to say that these other cases are suddenly moot. They're not, because lots of things could happen, including the administration working the shadow docket with the Supreme Court and trying to get the Supreme Court to basically overturn what the First Circuit just did. So until we get a confirmation, at least in our cases, until we get a confirmation from the government that they're done, we have some options as far as what our litigation posture is going to be, but I can tell you that we're not trusting the government as far as that they're even though they're complying with the Dorcas decision and cases are moving, we're not going to trust the government that they are not going to try and figure out some workaround to what's happening at the First Circuit. So I know we usually get questions about that. I wasn't on today's live stream, and I'm not sure it happened because I was trying to log in. I was having difficulty, and I'm not sure that happened today. So apologies for people that are here or looking for updates on all those cases. And other than the this one, we're not gonna have that tonight. But I did want to put out that good news as sort of the last thing on our list. And then we had some questions. So, Marshall, I don't know if you see the questions, but we'll put the first one out. And this is from our friend Amipat, who's usually on the litigation live streams that are on earlier on Wednesdays. Have we seen and he's usually the one who also asks what's going on with doctors, which Marshall is my witness that we discussed that today as far as that potential question coming up regarding doctors on the live stream. But have we seen consular H-1B approvals since the $100,000 fee is gone? We did talk about that at our lunch today, and I believe we have filed. So basically, it's not the consulate that's the issue; it's the USCIS basically not issuing the H approval without the RFE asking for the $100,000. So we have filed cases since the Boston H1 decision on the $100,000 fee has gone in via premium processing. But I think the decision came like less than like a month ago. So it takes some time to basically start getting cases ready to file and getting them out the door. But we have filed some cases via premium processing. So my guess is by next week, we might actually know how things are moving with respect to the $100,000 fee and whether they are complying with the order. I'm guessing they are going to comply. Also, September 21st. That's when this order no longer is in effect, and we have not seen anything from the administration yet seeking to extend that order. And I've been saying for months to people, if you ask for an October 2nd start date, and it's 10 days before October 2nd is after September 21st, that the government should not be RFEing you or asking you for the fee. And this is for months. I've been telling people since April that this is a legit strategy. And I have, so I don't know how consistently it's being followed, but there is no ban. There is no $100,000 fee after September 21st, both because of this case and because the Trump administration has not issued an extension. And they were supposed to basically do an evaluation last March and make a determination about whether an extension was warranted. Haven't heard anything. So it's gone for now. if the Supreme Court comes in, I don't think the Supreme Court will, because basically the tariff decision that came a few months ago is actually right on point here, where Congress, this is a tax, and the Supreme Court decision said the president can unilaterally impose a tax without Congress approving it. That's their constitutional authority. And it's kind of the same here. $100,000, they tried to argue, is just a fee, but it's a tax on there. There's no relation at all to what's necessary for the processing. So I think it's gone for good. And I don't think the Supreme Court is going to save the day for the administration on this. And we have a case in California, Global Nurse Force, still pending our preliminary injunction, and it's still sitting out there. So should something happen with the administration attempting to extend the policy, we have this hammer that might hopefully come down with our judge rules the way we hope, that will again prevent the administration from carrying it out. I'm not sure sort of why at this point our judge is still on the, hasn't issued an order on the preliminary injunction, particularly in, given what's happened in Boston, but we're still waiting. So that's that. All right. Next question. Have we seen green card approvals for 39 country bans since August? Well, first of all, the answer is I think we have been seeing across the board adjudications happening in the with respect to people that have been covered since August. So yes, they do seem to be adjudicating a lot of categories. I know in our own cases, we have seen some of the low-hanging fruit, like 765s and some of the others. Basically, keep in mind, the end of the Dorcas case doesn't mean your case is going to be decided immediately. What it's supposed to mean is that you're put back in the place you would have been in line had this policy not been in effect. And that's one that there's a lot of arguments about. What does that mean? Being put back in line, because the the line is unreasonably long, and we've told people you still might have to file a mandamus case if your case is not being adjudicated. Well, let's just say a case has a 6-month timetable. This policy went in effect, I think, was it September? I'm trying to remember whether it was like January, whenever it went in. Let's just say it went in on January 1st for sake of illustration. And the adjudication processing times are about 6 months. So let's just say everybody who filed in January that wasn't from the 39 countries, that most of those people were getting their decisions within 6 months. You should be getting a decision very quickly if they are following what they claim to the judges that they're following, which is they're just putting people back in line. On the other hand, if they take 18 months on average for your kind of case, and you filed in January, then you're going to have a hard time arguing that your case should be adjudicated immediately, when there are lots of people who filed in January that are not from the 39 countries that haven't been adjudicated yet either. So that's basically what they're saying when they're talking about put back in line. As Chuck Cook always says, there's no line. It's completely random, and it depends on the examiner, and it depends on where you file, and there's no consistency to how long these things are taking. So it is the saying when a case hasn't been adjudicated, well, we just put them back in line, Judge. That's not particularly meaningful. So there's that. And I guess that I would just say to people, if you're basically that this policy is set aside for a while and you still don't have a decision, the question is, and I apologize for I'm just like seeing now this stupid typo that I made. I'll try. Whoops. That wasn't me. That was the questioner. All right. Sorry about that. So if your case is still like well outside of when it should have been adjudicated, you probably need to file a mandamus case. if you were if a case should have been decided and because they're no longer citing the 39 country ban for it. And if you file a mandamus case, then if it is legitimately outside of normal processing times, you should probably have an argument to make. So this is something to talk to your lawyer about. But keep in mind, Dorcas and the cases that Impact filed and the cases that my friend Curtis filed and others have filed in this, they're not making your case go faster than normal. They're just trying to get your case adjudicated to get past this issue that was blocking adjudication at all. So if it's taking longer than normal now, you need to file a mandamus. That's not what that Dorcas was not a mandamus case for, slow processing of cases. It was just to remove this barrier. Okay. Somebody's asking how long a green card, how long is a green card applying or is taking? Depends on where you file, depends on what kind of green card you file. That it's not happening quickly. So I would expect Marshall 18 months probably for adjustments in the US or more.
Could be less, could be longer.
Yeah. Consular processing green cards, assuming you're not subject to baloney 75 country bans and things like that. If you're processing normally, what's a green card for somebody from abroad? And I'm not talking about quotas like that backlog.
Yeah.
1, 2, 3 or family cases. Just assuming you're immediately eligible for the green card. How long does consular processing take for immigrant visa processing, would you say?
Depends on the post. Always depends on the availability at the post, but could be 4 to 8 months.
Okay.
Longer.
Yeah. So basically, it's all over the place. It just depends on a lot of the specifics. Okay. Now we have the question on doctors and J1. So when we talked about it, so no policy changes. We did. So when we were talking about this, what we did note was that for the 39 country ban, which has been in place for the entire match period for doctors. So it's been in place since whenever it was, September or October, like late last year or January. I can't remember. Like there's so many of them, when it went into effect. But a lot when we were talking about this at our attorney meeting, and Elisa and Adam were saying that because they are in touch with a lot of residency programs, that there was a big shift in terms of matching away from doctors that, good or bad, away from doctors that were in the 39 country list, so that there were many fewer doctors that were subject to the 39 country ban than in a typical year from doctors from those countries. I don't know that we've seen the actual data. This is definitely anecdotal. But what that means is that, but we have heard about a number of doctors still who did not show up on July 1st in their programs because they are still not getting them. And we know as well that there are some anecdotal reports, and we tried to get confirmation, but and not just us, but like some of the organizations that represent residents, and we have not been actually able to get any confirmation that a single national interest exemption has been made for a physician from a 39 country. Nor have we, we haven't seen. We haven't seen litigation. We haven't seen a national interest exemption. So, as far as I can tell you, if a doctor is subject to a non-immigrant visa ban from one of these countries, they have not gotten a J1. Even if they've gotten J1 waivers, even if they've sort of like everything is completely normal about the situation. So So, all right. So this is for doctors to get initial J1s, or even J1. So that's on the initial J1s. On the H1s, I mean, of course, they're double banned with the $100,000. The $100,000 issue should be gone, but for the 39 country doctors, we still have an issue if they are seeking an H1B at a consulate at this point. What am I missing, Marshall? Anything, or is that accurate?
Sounds right. Yeah.
Okay. Okay. So, and I'm probably say you didn't think there was Impact Live. Yeah, I was. I was frantically texting my colleagues for that, saying I can't find the link. I can't get on, but I think Chuck must have had something come up today because he's the one that drives for those. Anyway, all right. And there was one last question that's coming on the EB5 issue. Priyanka, I'm not putting this one up because Marshall and I, neither one of us are EB5 experts, but send me an email with this question and I will forward it to somebody that I ask my EB5 questions to. I'm going to get him on one of these days, Matt Galati, who is our go-to on EB5 stuff. So, all right. Okay. Mountain is British, so he says that's why he's interested in my trip. Yeah, great time. Go to the Peak District National Park. It's awesome for mountain biking. I'm not a great mountain biker, but I did have a good time. Okay. Well, Marshall, it's 8 o'clock. We got through everything, and we got through a question. So, thank you guys. I'm not sure who's here next week, but I will probably be. And in any case, hope this was helpful, and we'll see you next time. Night.
Night.
Okay.